That the CBI has filed a status report in the coal scam. CBI wants a more financial power for the CBI director. More details are coming in from the apex court. Ridham Anand Bhardwaj is now joining us with more. What can you tell us, Ridham?
Radhika, very clearly they filed a status report in this case, very crucial because the CBI yet again filing another sealed cover report on its investigation in the coal scam. Extremely crucial because of the heated debate that's been going on in it. Let me first point to Times Now exclusive documents that have been accessed by Times Now on CBI's affidavits that they filed here. This is, remember, not the sealed cover report that the CBI has filed, but other applications that they have filed. I go on to read what is very pertinent because out of the 3 documents that they filed along with the sealed cover report, this is most important, Radhika. In this, they are very clearly saying that it is submitted that there is no requirement of sanction for prosecution in cases where court has either directed an investigation or is monitoring the investigation of the case. Radhika, this is really pertaining to what the government has been saying for several days in the Supreme Court. They've been asserting that they have the right to demand for sanctions and give sanctions in case any investigation is being done of their officer. Now, very clearly, an open war between the CBI and the government, because right here in this document, the CBI is asserting that there is no previous sanction that is required when the court is investigating the matter. Since several hearings that we've been hearing, the Supreme Court themselves have been saying this. They've been asking the government time and again why they need to have sanction powers when in fact it is the Supreme Court that is monitoring the investigation. Now we are seeing the open war between the CBI and the government, because now the CBI is asserting that it is respectfully submitted that there is no requirement of sanction for prosecution in cases where the court has either directed investigation or is monitoring the investigation of the case. They're also going ahead and saying that there are consistent judgments in this regard, and therefore they believe that the government should not be given sanction powers here. They're also saying, hence, the puzzle of the judgments rendered by the Supreme Court makes it clear the requirement of sanction is not mandatory in the court-directed monitored cases. Remember, Radhika, this is pertaining to the very controversial coal scam case in which the government continues saying they need to have sanction powers in any investigation. Since several times in the Supreme Court itself has been asserting why does the government need sanction powers, especially since the entire investigation is being done at this point of time by the Supreme Court itself. When the court is monitoring the investigation, why then does the government want to continue to have its powers? We continue reading this very interesting affidavit that's been filed by the CBI along with their sealed cover report, in which they write, the objective behind the enactment of sanctions section is to give protection to officers at the decision-making level from the threat of malicious and vexatious investigations and to relieve them. However, the said objective of Section 6 is fully achieved when a case is monitored by the court, more specifically constitutional court of the country. It may not be out of place to mention that courts are the repository of the faith of the people as well as the protector of the rights of the individual. Very clearly saying they do not believe that it is evident that prior sanction of central government is necessary under Section 6A, even in cases where investigation is monitored by the Constitution Court. They then go on to say the necessity of sanction from government would mean suspension of monitoring by court in the interim. Very clearly, Radhika, they are taking a huge and a very different view from what the government has been saying in this case. Since several times we've been heard the Attorney General, who's appearing for the government in this case, continue to say that it is in fact the government that needs to continue having sanction powers because it would lead to an anomaly of the section. In the coal scam, therefore, the CBI asserting what the Supreme Court has been saying since several days. Why does the government need to have sanctions in a case when there is an entire investigation that is being monitored by the Supreme Court? Now, in this affidavit, not only are they backing that particular claim that has been asked in the Supreme Court, the CBI is also asserting if the sanction power continues to be with the government, it will lead to an anomalous situation. It will lead to suspension of monitoring by the court in this regard, which means not only they are saying it is held even in investigation which is monitored by the Constitutional Court, requirement of sanction is mandatory, it would amount to suspension of the power of the Constitutional Court to monitor the investigation. At this juncture, it may be pertinent to note that prior and proper investigation is an integral part of the rule of law. very clearly they are backing the fact that requirement of sanction, if mandatory, would amount to restricting, very important words, Radhika, restricting the power of monitoring by a constitutional court up to officers below the rank of the Joint Secretary. An affidavit that is filed that is not only taking the side of the Supreme Court and the questions that have been asked by them, but they're also making their viewpoint clear. Remember, Radhika, this is the case in which for the first time we've seen the CBI and the government at loggerheads. It's for the first time that we've seen the CBI asserting its own powers. For the first time, CBI says they need more financial powers. In fact, in the other affidavits that they have filed in this regard, and I'll read out them, they are saying that the CBI needs to continue having financial powers, administrative powers of the rank of a Joint Secretary level and more. They're not only asserting that financial powers need to be given to them, but they're also asserting at this point of time that they've already asserted so in the previous applications. Hence, Radhika, what becomes very clear from these affidavits that they filed is that they do believe the CBI's powers need to be increased. They are therefore saying it is humbly submitted for presenting the report in the court, and an examination regarding admissibility and sufficiency of evidence collected during the course of evidence is required to be carried out. For finalizing the proper final report, facts of the case are required to be discussed. Facts of the case are to be discussed with in-house prosecutors who are appointees of the Ministry of Law and Justice. List of prosecutors with whom discussion is sought would be handed over to the Honorable Court. In fact, Radhika, at one such point, in one such case, they've also given details of the investigation themselves and what they've really done in regard of the investigation. I read out first on the powers of the CBI that they said here. They say the CBI is of the view that granting Director CBI financial powers equivalent to that of the DG CRPF as proposed by the GOI only partially addresses the concerns and needs of the CBI. The CBI has unique requirements linked to its work that still remain unattended. For example, the powers for engagement of qualified professionals, etc. They're also saying this means the budget for the CBI may be separately put up through Honourable Minister to the Department of Expenditure. Very clearly, Radhika, once again we see the CBI and the government at loggerheads.
And of course, the CBI fighting for more autonomy. Thanks to them very much for bringing in those details for us.